So I'm reading chapter 11. I did a jump. Chapter 11, the discussion continuity of the hearing. So it's paragraph 64 in the law. After the concluding partial hearing, a hearing will be held on the dates to be ordered by the court, in which the evidence of the parties will be presented. B. The hearing and the proceeding in which the hearing of the evidence began will take place consecutively, and the continuation of the hearing on the postponed date will take place within a few days, unless the circumstances of the cases require otherwise. In this regard, the court must ensure, as a rule, that the cross-examination of a witness will take place immediately and further to his main interrogation. Changing the date of the hearing. The order of argument. In the absence of any other determination necessitated by the circumstances of the case, the prosecution case will come first, followed by the defense case, bringing refuting evidence requires permissions on the court. How the evidence is presented. 67. The court will decide whether the main testimony will be heard orally or in writing. In deciding how to hear the testimonies, the court will consider the scope of the written and oral evidence, the complexity of the prosecution, and the nature of the dispute between the parties, while giving preferences of hearing oral testimony. In this will assist in discovering the truth and conducting the hearing effectively. If the court orders the submission of the main testimony in writing and the litigant does not submit an affidavit of such witnesses, the court may, without derogation from other powers, order that the party shall not be allowed to bring their witness or prove the fact unless the court is convicted that the affidavit was not submitted for justified reasons. Without derogation from the provisions of Subregulation A, in a claim for monetary relief in a district court in an amount exceeding 2.5 million new shekels, and in a claim for compensation for bodily injury, and a claim that arose the Road Accident Victims Compensation Law that was submitted to the district court, preferences will be given to given writing testimony if it's sufficient to assist in discovering the truth and conducting the hearing effectively. After the witnesses has been lawfully warned, the party who summoned the witness will interrogate him in the main cross-examination, and the opposing party may cross-examine the witness. The party who summoned the witness may re-examine him in a cross-examination regarding matters arising from the cross-examination. In respect of these remains ambiguity for the purpose of this sub-regulation. Counterparty means that any party who is the forefront of a material dispute with a party who summoned the witnesses of whom the court was permitted to cross-examine the witness. Objection to question. 68. In the event of an objection to the question presented by the witness, the objector shall immediately state the reason for wishes to prevent the question and shall immediately respond to the objection. The court shall decide on the objection to the question and on it admissibly immediately after the conclusion of parties' arguments, unless it finds that in circumstances of the case the decision should be postponed. The strange thing, I mean, a restriction order, against violence, the judge said that you have to take out all the people, which is very strange. I mean, why should you keep it confidential if someone beats you? I mean, it's not your problem. I mean, I guess they always get out from a conclusion that it's a spouse, but if you had a or in family, but if you have family that take also sabotagers or other people to break your bones, then it's not family. So why should it be with closed doors? Okay, the court's jurisdiction in the investigation. The court may summon any person to testify, to require any person present in the courtroom to testify, and to summon again for addition. I actually saw it, it was very interesting. And testimony until he has already been interrogated. B. The court may give any instruction in the framework of examination of a witness, including to ask the witness any question it deems necessary or to instruct him to present any document in its possession or control. Submit a copy of a document. 70. A party shall not attach an original appendix to the statement of pleadings and shall not provide the court with an original document as evidence, but only a copy thereof unless the court orders otherwise. If the litigant submits an appendix or an original document in accordance with the court's decision, he shall notify the court decision secretarial thereof in the written notice. It's real bureaucracy, but you have to know it. That will crowned with the words notice of submission of an original document. Haven't seen this, The aforesaid does not derogate from the obligation to present an original document where such an obligation exists. Presentation of evidence in electronic or digital media by a litigant. Very interesting. 71. So you have, the opportunity. A litigant who wishes to present evidence in electronic or digital media shall notify the court of his intention to do so no later than 3 days before the date of the hearing. The Director of Courts may order the format in which evidence will be submitted, and in the absence of such an instruction, in accordance with the order of the President of the Court, testimonial by visual conference. This I went to see criminal cases, and you could see from the prison behind bars, they take a picture. You put a flag, and they take a video of the where defendant. Testimony of visual conference. The court may permit the hearing of a testimony by way of visual conference within and outside the territory of the State of Israel in accordance with the instruction it may give. It is satisfied that the following conducting has been met. Have a sunscreen in my eye. Okay, so this is 72 and it goes down. 1, 2, 3 and all the... Okay. Actually very interesting. It's continue later. I have to clean my eye.